She's my client. I can have her do all sorts of things if I want her to.
You can, but you have to produce it.
And I didn't because she's not going to testify about it.
No.
That's not how it works. So if you intended to bring her to the stand, Mr. Rasmussen, and at that point we would have learned that you had testing being performed without any knowledge given to the other side, which is truly trial by ambulance. And she's not here because the court prevented her from being here because you violated Rule 16.1.
Please be seated. Thank you.
Okay, let's go ahead and set forth our appearances for the record. Your Honor, we'll Kemp, Pepperman, and City Partner.
Joel Odou and Matthew Kaufman on behalf of the water MCs.
Good morning, Your Honor. Good afternoon, Your Honor. Scott Rasmussen and Ryan Flanagan on behalf of Hanna.
Good afternoon, Your Honor. Rob Robbins from Milwaukee Insurance.
All right, is there one issue we have to decide outside the presence? Or we don't need it?
We're going to show the Casey Aiken deposition first. That's the other one you need to tell them before we can talk about it. We got a little more time than we thought.
Okay.
It's only about 15 to 20 minutes long.
Just one more thing, Your Honor, just so you're aware, I am gonna leave, with your permission, I'm gonna leave a little bit early today.
Going home, huh?
Yeah,
Good for you.
trying to catch an earlier
I
flight,
understand.
so,
And that's fine, sir.
thank you.
Anything else?
Your Honor, we'd like to put some parameters on this and anticipate testimony of Dr. Babcock or Mr. Babcock.
Dr. Babcock.
Okay. Dr. Babcock. Your Honor, it's our belief that his intended testimony has been curtailed by the decisions during the motion limine arguments. And we've tried to reach some accord, we've not been able to. I have his original report, his initial report, I should say, and his rebuttal report here. And we'd like some assistance from the court to determine what opinions would be allowed so that we don't spend a lot of time at the sidebar today.
And in a general sense, what is he being offered? His opinion?
I'll let Mr. Rasmussen tell you the areas, and then we can inform the court of the opinions we believe will be true.
Based on Dr. Babcock's background, Your Honor, he will be testifying with regard to how an ORP measures things. He is someone who has used an ORP meter, and he'll talk about how an ORP works and what it does. So we have someone that's actually done that and used one. Number two, and these are out of his conclusions, that real water used an ORP, and that it was to measure the real water in the concentrate area and in the final when it was going to go out. And what was it doing? Number three, he's going to talk about, and it's in his report, a lack of basic analytical knowledge, of chemical knowledge of Casey Aiken and Blaine Jones. That they don't have that background. This is
Okay, here's my question. How's that a defense in a straight products liability case based upon failure?
because if they don't know what they're doing to, they know what is in the warnings and understand them analytically.
Here's my point. I think we've had testimony on this issue, even from your client, that they were selling these work meters to individuals that were using them to measure the, I guess, they give ORP readings on swimming pools, right?
Yes, Your Honor.
He even admitted that. The president admitted that. And so if you're trying to say that this is some sort of highly technical type machine, a medical instrument that required some sort of professional certification and or training, that wasn't in the manual.
No, Your Honor. That's not what I'm suggesting by that. The analytical knowledge that they failed to understand is that an ORP reading will not tell you if there's chemicals in water. And based on what he's seen from their testimony, he thinks that they were trying to rely on it for that.
But I don't think there's any
There's no testimony to that, Sean.
And here's my point. I mean, everyone's kind of agreed what the ORP meter does. It gives positive ORP readings out of the box, and you have to condition it for negative ORP readings, right?
No, you can read it right out of the left from negative, it just is more effective if you condition it. That's one of the basic mistakes that's in this case. It will read negative, in fact, Casey Aikens testified to that.
But
He
how
actually
long
said
would it
that.
take to?
Hours, days.
That's
Yes.
how long
They
it
don't
takes
know
to
yet.
oxidize.
That's what the evidence.
Yeah, that's not true. It doesn't take I mean, to get through, that would mean that these guys are sitting for hours to days, holding that in, that sample at real water, hours to days.
What does the
It's
tip card say?
not- The tip card says it takes 40 days to oxidize,
To oxidize for what purpose?
to oxidize the probe, so that
Oh,
will
wait a
then,
second. Wait. Oxidize, we don't have to play semantics or name games, right? I understand we're talking about the probe. I understand the probe, it has platinum tips. I get that. I've heard enough of this case in that regard. My point is really focusing on this. I don't think anyone is, are you disputing the fact that the tip card says if you want to oxidize for negative warp readings, which it does say, it could take up to 24 hours? Isn't that what the tip card says?
48 hours. Your Honor.
40 hours, well, yeah,
Yes.
2 days, right? And then we have testimony, it can take up to 5 days, right? So I'm trying to figure out, so you're offering him for the purpose of saying, look, they were negligent,
That's, like I said.
right?
It doesn't make any sense in the context of a strict product liability case. It's not a defense.
The,
But I mean, at the end of the day, what you're saying is, look, Judge, they were negligent in the operation and utilization of the warp meter. Because they didn't have the requisite training required to use an warp meter.
the end of this discussion that I believe the plaintiffs have stated in this hearing is that it was taking inaccurate readings after oxidation, or improper oxidation for that matter, but it was taking inaccurate readings. He's going to go through that, part of that as well. Remember, Dr. Najim talks about it degrading. He needs to talk about what does that mean? What does it mean in terms of hydrazine degradation, and what effect it will have on readings?
Here's my impression as to the current status of the evidence. The plaintiff is taking the position that there were no instructions to properly advise users as to what the appropriate time period would be to oxidize the platinum probes.
Thank you. And we have it in the tip card that it takes 48 hours.
You have testimony that it takes 4 days.
Yes, but it says in the tip card and the instructions it takes this amount.
Right, and it's all confusion. So the fact that I'm really trying to, it seems to me the essence would be this, and tell me if I'm wrong. You're saying that these individuals weren't trained to use a warp meter. Consequently, they were negligent in the production of real water.
They were not properly trained. Yes, on real water, I would agree that that's evidence. That's not really what he's talking about here. It's whether or not the warp meter, based on oxidation, okay, confusing or not, does it read accurately? Right out of the box, it will read negatively. Now, to say that it,
But here's the point, and we can't overlook this. Read negatively to what level?
And how
Right,
long
because
does it
we
take?
know at Kangen water levels at a certain level. Because, for example, what was Kangen water? That was
500 to 800.
5 to 800. Does it read 5 to 800 out of the box?
Yeah.
yes, in fact, Blaine Jones was doing it for the concentrated negative 550. That was the testimony we just heard.
And the question is, how long does it take to actually get that reading out of the box?
Exactly.
And that's what we've said so many
Hours to
times.
days.
And that's what the court started, that's the first question out of the court's mouth. How long does it take after this 48 hours to get the readings out of the box? And the answer was, from Jason Brown, it could take hours to days to get it. Because no one has tested it, including your expert, Babcock.
Yes,
And that's the problem that you have, Mr. Rasmussen. Your expert did not do tests based upon this meter for this case, and now you want him to come in with some general propositions for which he has no support. It's just not allowed.
He has done the testing. This court has denied that because it was not a duplicative test solution. That doesn't mean that out of a box.
When you say I denied it because it wasn't a duplicate test.
There was a motion by the plaintiffs asking that the testing done by this particular witness be excluded as evidence. The reason is that the test solution that he used was at -148, not -225. The reason for the difference, as I explained, was that my client did not have the tube, the titanium tubes, the Russian tubes, and we went through that and said, hey, we can't get these Russian tubes. You ruled, and I remember the word right now, is the Hallmark case requires similarly situated, substantially similarity, you're right, thank you, Eric, and you said, no, it needs to be duplicative, and that was fatal.
I don't know if I said, did I say?
Yeah.
You did use the word duplicative, it's on the record, we actually looked it up.
You said it's not duplicative and it's not substantially similar.
Right, that doesn't sound like a term I would use, you can read it, so to refresh my recollection, tell me what it said.
I don't have it in front of me, Your Honor.
Okay.
But if you'll give me a minute, I can find it. I don't, Your Honor.
I mean, I mean, and that was Williams, right? Is that the Williams case?
Hallmark.
Hallmark. Anyways, I believe we're in agreement on several things. If we get to that spot where they'd like to do something, but we've already discussed this, and you says, we'll deal with it at the time that objections are lodged. You said that.
So we did agree to settle them, Your Honor, before the court.
Well, here's the thing, and this is important to point out. Yeah, we deal with issues when the objections are lodged, I agree with that. But I don't know if we went into great detail as to specifically what the basis of this objection would be, as far as the record's concerned, because it goes to a foundational issue. But just as important too, it goes to an issue as to whether or not that would be an appropriate defense under the facts of this case.
Right. That's correct, Your Honor. So if Mr. Rasmussen would rather proceed and then we can deal with the issue.
He can make an offer of proof on specifically what he's going to say, so I can clearly understand what it is.
How does it, I can, Your Honor, he's going to talk about how an ORP meter works. He's going to talk about real water use in ORP as the primary determining factor of whether the proper amount of mineral concentrate was added to their product, whether or not that was something that an ORP meter can do. He's going to talk about measuring ORP would likely not identify whether certain contaminants were present in the water. Testing conducted by the US FDA identifying hydrogen in samples of real water. He's going to talk about...
But we know the ORP meter does not test for hydrogen.
Yes, we do, Your Honor, but this is the first time we'll hear a chemist say that. I don't know that they get that, but we have a chemist, someone who's an expert in this, being able to say that for the first time.
But why does that matter? Because no one has, but this is my point. What's the fitness for a particular purpose in this case?
Right.
Is it to test for hydrazine or not?
That's right, Your Honor. We have no,
You said,
there's no
I recall you
argument.
said that it would take a negative reading, and I asked, any negative reading? And you said, yes. I said, even -1? And you said, yes. So that's what I recall it being, Your Honor.
But wait, that's not the answer to my question.
Right.
My question is this, has anyone at any point, I mean, because let's look at the claim for relief as alleged by the plaintiff in this case. Are they alleging that the ORP meter was defective because it could not determine whether or not a solution had hydrogen in it?
I'm not making that claim.
Your Honor, that same area, we'll be talking about hydrazine. He is a chemist. He'll be offering what effect hydrazine will have on ORP readings.
He never tested for it.
Literally, it's right there.
Yeah, but he never
Right in
tested
section
for it.
5. And then it's also in the rebuttal report when we talk about hydrazine.
How is it relevant? And here's my
Okay,
point.
that's a good question.
Just because a doctor can opine on injury causation doesn't mean he can offer up an independent alternative causation. Just because he can testify potentially on plausibility theory doesn't mean he can offer up a plausibility theory unless there's an appropriate foundation, number one, for the opinion, and number two, whether it's relevant.
Dr. Najim testified in court that hydrazine is an alkaline substance that will affect the negative ORP of a solution. I believe Dr. Babcock in his report gave a rebuttal report that he will agree or disagree with Dr. Najim with regard to that specific evidence that was provided to this jury. And that is in his rebuttal report.
And I want to make sure, once again, it's not whether, I mean, he's not saying that the ORT meter would be used to test for hydrazine.
No, sir. No, Your Honor. I'm sorry. That was implied. No, Your Honor. What he is testing, what he is doing is going to say, he can't tell you what it is, but if hydrazine is in a solution, it becomes more negative. In fact, that's what Dr. Najim said. And I said, so when you make the concentrate, it's going to be at its most potent right then negative ORP reading. Dr. Najim then said, yes, that's true. And then every day after that, it degrades, and that's part of your testimony. Yes, it is. It becomes more negative, more negative, more negative. Or no, it becomes more positive because it degrades. Excuse me, I said that backwards. He needs to be able to counter that because that is what Dr. Najim did. And he did a rebuttal report with regard to that, Your Honor. Writing his opinions.
Let me ask one question. Did your expert actually perform any independent testing on this theory?
He has not done any because he has all the experience having used an ORP meter with hydrazine in solutions when he worked in the aerospace industry for a rocket fuel and rocket engine making company. He's done all this.
Okay, so you've answered the question. He didn't do any testing with alkaline water as opposed to strictly fuel. Let me finish. And I appreciate that response. The other thing I wanted to make sure I understood you on, Mr. Rasmussen. If you're indicating that the level of hydrazine can affect the alkalinity of the water, are you telling us that your client's meter should have informed real water that because the alkalinity was lower, they should have added more concentrate? I mean, that's what happened, but I'm asking if that's what you're saying.
No, what I'm saying is that, what I'm making sure is that when Casey, strike that, when Blaine Jones makes the concentrate, he's getting readings of negative 550. That was just on the video we heard today. Dr. Najim says that hydrazine degrades, okay? The other part of that is that he said it's at its most negative because hydrazine is a part of that, because it's an alkaline element. Our doctor will be saying, okay, that's it, but with the degradation, what happens? With degradation of hydrazine, the negative readings will go from negative 550 back up to negative 130.
Let me back down.
Back down towards zero? Yeah, that's probably the wrong way to say it, but yes. It's all about Dr. Najim. I've got it right here in the rebuttal report.
I got your rebuttal report right here, Mr. Rasmussen, and based upon what I believe the court's decisions were, we believe that several of these opinions are excluded. And so I came over to you and tried to go through them with you. I think
We did on the report, but not on the rebuttal.
I got the rebuttal right here.
Okay.
And it's our belief that opinions 4 and 5 of the rebuttal will be excluded. I don't know if you agree.
What are opinions 4 and 5 for the record?
Number 5 of the rebuttal report, the effect of hydrazine on ORP and ESI measurements indicated that if it was present in the real water concentrate when the ORP was measured, a noticeable difference in ORP may have been observed. This indicates that hydrazine entered the product stream after the ORP was measured. Again, Your Honor, there is no foundation for it. It's not being offered to, I believe, better greater than 50%. And it says may have been observed. And there's no testing foundation for the foundation of this opinion.
Well, here's my question. And I don't want to get astray where the issue is. Where is that in the instruction manual?
It's not. It doesn't say that it will test for hydrazine.
That's correct.
And in fact, I was looking at the box. One of the questions the court asked brought me back to the face of the box. And it says to measure pH, ORP, EC, TDS, Lux, and Temp. I'm trying to figure out how these opinions are relevant to the plaintiff's claims other than the ORP measurement. And so when I look at these opinions, I don't see how they're relevant. I don't see how they defend against our claim. And I still don't see the foundational support for opinions 4 and 5.
Here's my next question, because we just talked about opinion 5, I think.
That was 4.
What was number 5 then?
5 is only measuring ORP, will not identify contaminants and will not necessarily change the ORP reading. This was demonstrated in ORP measurements taken on a water solution before and after the addition of toluene, T-O-L-U-E-N-E.
Which report are you reading?
Rebuttal.
Oh, I'm sorry.
At 10 times the US EPA maximum contaminant level in drinking water standards. The effect of toluene on ORP was negligible and likely would not have been noticed by real water employees in measuring ORP given the observed range of ORP values and measured in production. Again, I don't know how that has anything to do with plaintiffs' claims against Hanna and Milwaukee. And in my opinion, 4 and 5 are actually inconsistent, Sean.
What about number 4, Mr. Rasmussen?
Number 4, the effective hydrazine on ORP is, I believe, relative because of the plaintiff's claim that it gave inaccurate readings. And we now have a reason under number 4 to tell you what the effective hydrazine will have on ORP readings, and that's what number 4 has to deal with.
Now, I might buy that if this was potentially a design defect case or something to that extent, that it was designed to detect hydrazine and failed to do so. But that's not what the case is about. The case is a failure to warn case. So it seems to me that if we're going to interject the fact that this work meter fails to, or wasn't designed to
Detect
hydrazine, shouldn't that be in the instructions somewhere or something like that?
And if they're conceding that this can now be in part a design defect, and we can add that to this claim based upon its failure to detect hydrazine, if they're experts saying that it should have.
No.
Well, that's what 4 and 5 is suggesting.
No, I understand. No, let Mr. Robbins talk. We haven't heard from him on this issue, sir. I want to listen to him.
I just got lost on that whole issue, you know, there can't detect hydrazine.
I mean, we all agree.
Can't, and there should not, and I argued up there for 40 minutes the other day, yesterday, that shouldn't be a warning on it either, because who the heck would know that somebody would produce hydrazine as part of their manufacturing process in a bottled water product. So I don't know where this conversation is going, but it ain't going there because it cannot detect hydrazine. That's not what it does. We know that for a fact. So I'm putting that on the record. There's not going to be testimony about that.
There won't be any testimony of that it detects hydrazine. That's not what I'm saying. What he's saying is that because our instructions were so inadequate at the end, it was inaccurate. The readings that Casey Higgins, for instance, took were inaccurate. That's what they're going to claim, okay? The oxidation, 4 or 5 days, 48 hours, whatever it might be, the product that they were using was inaccurate. The alternative to that is, did the concentrate chemically change from when the concentrate was first made to when it was actually added into the mixing tank? And as a chemist, he can talk about that. In other words, this is why it changed, not because of the instructions or the lack of oxidation of the probe.
Now, here's my question, and understand this. I have no problem if everyone said, well, Judge, your recollection is incorrect. But it's my recollection that the testimony in this case is essentially this. Your client never tested their instrument as it pertained to oxidation of the platinum probes. So to determine when would be the appropriate conditioning period and what would be the level of hypothetically vinegar to make sure that the probe works effectively when it comes to negative ORP readings, something to that effect.
Your Honor, that's a great question. I did that testing, and you said that that can be allowed.
It wasn't an exact test. It wasn't a replication of the test.
Wait. Both of you, wait. But that's not what I said. I wasn't talking about that. I was talking about your client.
We did that testing.
What did he, am I missing something?
No, my client did it. You are not allowing Laura Brown to testify, and that's okay. We got it.
Didn't Mr.
Oh,
Savaggio?
now we get to it. So Your Honor, I appreciate what Mr. Rasmussen just said. His client
But this is
whoa, Scott, you just stepped into it, let me at least, let me put this on the record right now. Mr. Savaggio attempted to testify, or did testify, that Brian Moore, who's deceased, died in 2018, the predecessor to Mr. Jason Brown, must have tested this thing to determine 48 hours was the appropriate amount of time as a part of creating the tip card. That's the testimony. Now, we find out, whoa, Scott, it's too late, man, the horse is out the barn.
I want to see the test results.
So we don't have, not only do we not have the test results, which should have been produced as part of 16.1, now we find out that Laura Brown, someone who's not properly designated in this case, actually did the testing, and we have no results, we have no documentation, we have nothing on that. Now, if I had known that, that certainly would have been added to my motion to strike. Because to withhold test results related to a failure to warn claim that goes back to the tip card, that is ridiculous.
That's fine.
You just said that's what she was intending to testify to.
No, she wouldn't have, because it's out.
I wish we could play the
I
tape
can't do
back.
any testing on that. It's a warnings case.
Yeah, but you said she did the testing.
She did,
And you haven't produced that test results, have you?
because it's a warnings case.
Whoa. Thank you.
Then why are we talking about testing for hydrogen and all these other things?
Your Honor, if they did the testing that in any way relates to this case, which he is saying it does because he wanted to get Ms. Brown in, it should have been produced under 16.1. And in our responses to our interrogatory, he should have identified her and in fact, explained her intended testimony under 16.1. None of those things were done.
Okay.
So we have a violation of Rule 16.1. We have a violation of Rule 33, interrogatories.
Which,
Scott, just listen. How about this? You interrupt, and when you finish interrupting, I'll start again.
no, I'm done.
Okay. So now this is what we find out, John. So we can address that later. I want to get over this. I think that brings another issue to light. I cannot believe that Mr. Rasmussen, knowing the rules as well as he does, would not have identified her, produced the test results, in this case, a long time ago. I'm sure Real Water would have loved to know if that meter somehow, in some way, could have detected changes in alkalinity based on the presence of hydrazine. They would have loved to have known that in this case. But right now, what we do know, right out of Mr. Rasmussen's mouth, is that Laura Brown did some form of testing that was not disclosed. He intended to put her on to have that information discussed in front of this jury, and before or without providing it to us. That is an issue that I would like to take up before we do closings, because I think it does affect this case and the ability for Hanna and Milwaukee to go forward.
Mr.
No, hold on.
Mr. Odou, is you my answer?
Your Honor, I'd like to know a little bit more about this before I take a position, but this sounds like a bigger issue than I'm aware of, so I'd like some more information.
I understand. I just don't want to overlook this.
I appreciate that, Your Honor.
Mr. Robinson.
Hold on one second. Yeah, I did incriminate Mr. Robbins' client. I already see why he's getting up. Mr. Rasmussen was speaking for his client, not necessarily for Milwaukee.
Correct.
So I will not. The Savaggio played, he's a president, vice president, and president of the companies, vice president of operations for Hanna, president of Milwaukee. But I'm not going to attribute this to Mr. Robbins at this point because this came from Mr. Rasmussen, and I believe he was doing it in defense of his retained expert. And I don't know if they're jointly retained at this point. I will have to deal with that if there is a nexus on this issue. But that's an issue, Your Honor. And I certainly don't believe anything Mr. Rasmussen said supports allowing what I believe to be opinions 4 and 5 of the rebuttal report. And we haven't read these in the record, but we discussed this with Mr. Rasmussen. Opinions 4, 6, 7, 8, and 9 of the original opinion. And I know we have a jury sitting out there, so I don't want to belabor this issue any further.
All right, that leaves me with 1, 2, and 3.
No, I want to hear what you have to say. We're not done yet. Let's go ahead.
Okay, real simple. Laura Brown has done testing, doesn't mean that I was going to put her on the stand to do that. I believe Mr. Parker was making an assumption as to whether or not she would actually be able to talk about the testing she's done, because I haven't provided that. I can't do that. But her,
Why couldn't you have done that during discovery in this case?
why couldn't I?
Yeah.
Because it wasn't done then. So she can't talk about it, okay?
So when did
She didn't close the discovery in June.
when did she do this testing?
She did it back in March, but her conclusions hadn't been done. She's not, she was going to, here's what her testimony was going to be about. Now that we have to, full disclosure, so you've got it down. Her disclosure would be, she's a troubleshooting person at Hanna, not at Milwaukee. If a customer calls in as that support and troubleshooting and says, I've got this issue, what can I do with it? If it's like, oh, you need to put a battery in the thing, then she'll take care of that. There's no ticket, as she calls it, that's created. If it's something more, then she takes that issue and she goes to R&D. If it's on a Milwaukee thing, she'll never see it, or the Milwaukee stuff can go up through that ticket situation, that would go over to Romania, and they would troubleshoot it and do what needs to be taken. It's, do we even do anything about this? That's not Carl Savaggio's place at Hanna. He doesn't deal with that because he's over facilities. But she's there to tell you, this is what happens when we see issues. And this is when we revise the instructions or whatever needs to be done to take care of things. That's what she would testify about.
So the testing she conducted wasn't during the ordinary course of business. It was testing for the purposes of this litigation after the close of discovery.
Correct. But it started before discovery was closed, but it was not concluded. We have no results on it. It will not be offered as evidence, and it has not been offered as evidence. Remember, you and your clients can do whatever you want at any time on anything. And by the way, she did not use a duplicative testing solution. Okay? So the testing that she's doing isn't going to be able to be used in this case and can't be.
Your Honor, we got another case in here, Brown, that discovery's ongoing. We got about 20 others that, it's September. This was done in March.
So they tried to bring a witness that had done secret testing that wasn't disclosed in the discovery process to put on the stand and really ambush us with this secret.
We weren't going to do that.
You tried to call it more about it.
I did, about how you do the ticketing process.
I'm sorry, that's not what you said,
I
but,
just did.
okay, you just did now. I mean, it's a convenient thing to say at this point, Mr. Rasmussen, but if she was doing the testing in March, in terms of dates, the original initial expert reports were due March 24th, the rebuttal April 24th, and the close of discovery was June 9th.
Agreed, and she didn't
So-
offer one. So she couldn't have been an expert here.
But she did testing. She did testing.
She's my client. I can have her do all sorts of things if I want her
You
to.
can, but you have to produce it.
And I did because she's not going to testify about it.
No.
That's not how it works. So if you intended to bring her to the stand, Mr. Rasmussen, and at that point, those questions could have been asked. And at that point, we would have learned that you had testing being performed without any knowledge given to the other side, which is truly trial by ambush. And she's not here because the court prevented her from being here because you violated Rule 16.1.
Or the interrogatory answer.
Or the interrogatories under Rule 33.
Okay.
Your Honor, we still got this jury sitting out here, and we can deal with it as it comes up, but we put on the
This
record,
was
I
going
think,
so smoothly until the last day,
I agree, Your Honor.
right? And then we had hiccups along the way.
Your Honor, just
Yes, sir, I want to hear from Mr. Odou.
Just very quickly, we need to look at this issue. There was a special master order November 21 of 2022 that we have to look at. And I just want to reserve my right. I'm ill-informed on this issue right now, so I'm not taking a position. I just need some time to look at this.
I understand.
Your Honor, I have to mention that this, I understand we have the jury waiting, but it also directly goes to Dr. Babcock's proposed testimony because after what we've just heard, it just further solidifies our concerns that they're bringing him in here to start asking him about testing, to say that, oh, you can oxidize the probe in 5 minutes, or if it doesn't matter, there's nothing wrong with the warnings because we tested it and it was fine and it doesn't cause any problems, and it's get rid of the hours versus days from the managing speaking agent in Milwaukee, and forget about inconsistent readings. There's none of that. That's what this is through Dr. Babcock. That's why they want to go outside his report. They want to go around your in limine order, which we moved for this exact reason, and bring Dr. Babcock on and have him testify to all the stuff that they wanted Bora Brown to testify to but couldn't, that they wanted to get in through her secret testing, but who knows? To me, it infers that testing didn't turn out too well for him, so that's why you deep six something, not because it proves your case. So these are kind of intertwined concerns with Dr. Babcock's testimony that I think we need to be very clear on before Dr. Babcock takes a stand, especially given the confusion and the questions about prior lawsuits and untruthful testimony on that. This has just gotten to a point where the confusion is adding up, and I have significant concerns of prejudice.
Yeah.
Mr. Odou, or did you find something else?
No, we need more information.
This secret testing issue was a hot issue because there was a concern that people would do testing on water bottles, retail water bottles in their possession, and that they would test them, they produced the results they wanted, they wouldn't produce them if they didn't. So this was a hot issue. It was fully briefed twice to the special master. The special master said no secret testing, but you did it in the context of real water.
That's correct.
Okay, so I don't know that this order explicitly applies to it, but the philosophy underlying this order does. But more importantly, come on, we had requests for production for any testing. We had interrogatory answers for this. He tried to put the witness on this week to blast us with this secret testing.
No, I told you what, the whole thing was about the ticketing system at Hanna. That is all.
But it's hard to argue about it in the abstract without seeing the secret testing. Now we know that there's secret testing. I think we have this problem.
She's a troubleshooter at the company. She tests all sorts of things, all different kinds of equipment. This just happens to be one of them. What's her experience with that? What was going to be testified about?
And she tested for the purposes of this litigation.
She was involved with Dr. Babcock in the testing that he did to see whether or not what he was doing and had stuff. You've already excluded that. It's out.
So, Your Honor, how do we know at this point what testimony he would be giving that would be completely unrelated to anything he's done in participation with Ms. Brown? We don't know because we don't have her information. So now, at a minimum, the court's faced with potentially having to strike opinions or strike the witness because we don't know the level of participation with Ms. Brown. Now, we certainly don't have the results of any tests she's performed.
We did give you the results of Dr. Babcock's testing. Yes, that's what she was involved in.
So let me make sure I understand Dr. Babcock's list.
So there are, in his original report, which was done in March 24th and 23rd of March, he said the following, which I believe Mr. Parker said, yes, that's fine. 4B is a measure of the ability of a solution to generate or accept electrons. It goes on. Number 2, real water used for the primary determining factor of whether the proper amount of mineral concentrate was added to the product. Number 3, a lack of basic analytical knowledge was exemplified in testimony by real water employees Casey Aiken and Blaine Jones. Number 5, measuring ORP would likely not identify whether certain contaminants were present in real water, and testing conducted by the US FDA identified hydrazine in samples of real water. Number 7, conditioning the probe in distilled white vinegar is instructed on the tip card. The rebuttal report, opinion expressed by plaintiff's expert Dr. Issam Najim regarding potential hydrazine formation pathways during water electrolysis are unfounded and contradictory to a publication argued by Dr. Najim himself, due to the solubility of nitrogen being well below the concentrations of hydrazine measured in US EPA testing. Formation of hydrazine during water electrolysis was highly unlikely. Number 2, from the rebuttal report.
What does he mean by that? He said there's no hydrazine in the water. Is that what he said?
Nitrogen, Your Honor.
Again.
2,
That's right.
Citizen cause of action complains motion for leave to file amended complaint on order shortening time. Cited several statements in support of claims that the M35 meter was defective and unreasonably dangerous. I think that one's been abandoned. We're not saying, they're not saying anymore that it's an unreasonably or unreasonably dangerous instrument. So he probably will not be testifying today about that since there is no, there's even on the verdict form anymore about an unreasonably dangerous match. Each and every one of the statements are shown to be flawed, but that's what that is. Number 3, in testing conducted by the USFDA on real water samples, utilized approximately 11 different types of analytical chemistry instrumentation measuring orderly using an orderly meter like the Milwaukee and 500 would be inappropriate to identify whether water contaminants are present or at what concentrations.
Your Honor, may we interrupt for just 1 second and ask the witness to step outside?
Yes, we may. Here's my, I mean, at the end of the day, and this is what it comes down to. I know you went through a laundry list of what his potential opinions are, but for what purpose is this witness being offered?
At the end of the day, just discovered another problem that probably ends this. Can you put that up, Shane? Mr. Rasmussen just got done saying that Laura Brown provided the testing to Dr. Babcock. This is
No, we didn't say that. And if I did, I'm mistaken. That's not what I said. He did the testing. She was there to make sure that he had the MW500 meters.
Okay, well, where's the, is this the right page,
Yeah, starting at line 11.
starting at line 11?
Page 15.
Yeah, this is the right page.
That's 15. You sure it's volume 1 or volume 2?
15 starts at line 11.
2 depositions.
Volume 1.
You got volume 1, Shane?
He does.
So wait.
You sure you're looking at volume 1? That's volume 1.
Here, let me just read what you had there.
Let me see what
This
this
Babcock? Well, that's the rough draft. You're on the rough.
Sorry.
Give him a keyword so we can check it.
It's the Babcock.
15. This is what the testimony reads. The report mentions a technical review by Brian May. Who is Brian May? He's a consultant in the chemistry group. And what is his billable rate, blah, blah, blah. Question. Did anyone other than, okay, there we go.
Here it is.
Question. Did anyone
It's on the
other than
screen.
You and Brian May perform any work in connection with this case? Yes. Who else provided work on the case? Names 1, 2, 3, 4 people, and he says that's all he knows. Doesn't talk about this Laura Brown person, who now Mr. Rasmussen says was present when he was doing this.
No, she wasn't. Let me make sure that the record is straight. Meters had to go from Hanna to Dr. Babcock in California at the laboratory he did the testing with. She's the one that made sure those were sent to him. That's how she was involved. In other words, we were testing the meters. That's what's been excluded. But meters had to come from Hanna to be tested. She had to make sure they were there. She had to make sure what was sent. That's what she did. Yes, she was a part of that. I can't say that she wasn't, but she made sure that the meters got where they were. She's in the troubleshooting department. That's what she does.
So that's
The problem is you
testing.
said
She
that
just nailed
you
the
said
meters.
she did testing. You said she did testing.
Okay,
And
she
then we
was-
said, I'm sorry, Mr. Rasmussen, you said, and this is what started this whole conversation, that she was involved in testing. That's what you said. And so then we asked, well, what testing did she do? And you said her testing's not complete yet. You said she started it roughly in March. And then I gave the dates in terms of the discovery deadlines for the expert initial and rebuttal disclosures, then to close the discovery. And then Mr. Kemp said, well, are you planning on using it in this case? In response to the court asking, do you intend to use it in this case? And then Mr. Pepperman said, we have other cases that are going forward. Are you intending to use them in those cases? And then we went back around to Rule 16.1 and Rule 33.
And actually, Teddy, Mr. Parker, you were slightly incorrect there. How this started was when Your Honor asked, it's my recollection that there was no testing done by your client. And Scott Rasmussen responded, well, there was testing done by my client, but Laura Brown was going to testify about that testing, and you precluded her from testifying. That's how it came about. He was asked if his client had done any testing, and he said yes, Laura Brown had done testing. He didn't say Laura Brown mailed meters to Dr. Babcock.
Yeah, I would just like to know for the record, clearly and without interruption, what Laura Brown did, because this, I still don't have a full grasp of the issue here.
Laura Brown is my client, sent the meters, shipped to Dr. Babcock. She then saw the testing being done.
She didn't
Observed
do
it.
her own,
What?
I'm sorry to interrupt, she didn't do her own testing of any kind.
She did, she observed it. She checked to see if everything was right. In other words, is this the meter? In other words, she's there to say, okay, is this an MW500 meter doing? Is this the parameter that he had to go collect himself and during that testing? Did they, what were the results that they got? She confirmed, yes, these are the results that they got. That was what she did, but this was all driven by Dr. Babcock, but we definitely were involved in making sure that he got the meters to be able to be tested.
Judge, the secret testing was with regards to warranty work is what he first said on both Hanna and Milwaukee meters.
Not Hannah.
And you know what, we can't lose sight of this one fact. And to me, this is why the testing issue was potentially germane to this case in one respect. Was there any testing done to formulate what types of warnings should be given to consumers who use the product to determine whether there's an appropriate negative or reading? That's really and truly where it all came to. And so we're talking about testing that occurred before this event, after the conditioning kit was disbanded. Was there any testing done from that point? Was that 2017?
Yes, that's correct.
Yeah, from 2017 up until this event. Because, yeah, you had the conditioning kit that had specific chemicals that were banned in Europe because they were carcinogens contained in it. And they stopped using that conditioning kit. And so, yeah, there was a tip card placed, but at the end of the day, we can't lose sight of what would be potentially the purpose of testing. That would be to give the appropriate advice to users of the product, right? On how to condition the platinum probes and the tips to the probes to enable that to render a negative order reading, right? And so I understand the argument is, well, Judge, it would do it straight out of the box. Well, if that's the case, then why'd you give a tip card? If that's the case, why were you giving all these different types of recommendations that varied, right?
That's right.
And so the point comes down to, and I get it, if there was no testing done of these meters to make a determination as to how to make them effective and consistent in negative order readings, then that's a problem, because that goes to the very essence of whatever warnings you might have given or directions you might have given. That's really and truly what the case is all about. And there was no testing done between the time the conditioning kits were no longer sold in the United States, right? And were banned in Europe. And then there was a tip card put into place, but there was no testing to determine what should be contained on the tip card, what should be used or contained in the owner's manual.
That's right.
Brian Moore did that testing. There has been evidence for that, Your Honor.
But that wasn't produced either, Your Honor.
Brian Moore's passed away, you're right.
I mean, but that's the issue. That's the issue. So in essence, right now it appears to be the current status of the evidence would be essentially this. Yeah, there's a tip card, right? We can agree. Yes, there's a manual, I guess it's a 4-pager, but whatever recommendations were made weren't based upon testing.
That's right.
That's the case.
Carlos Odou gave evidence, never mind. Talked about Brian Moore doing testing.
So Judge, the real problem, I think, is the discovery violation because they didn't produce the testing.
We did produce it. Dr. Babcock gave you
I don't have Laura Brown's testing.
We don't have Brian Moore.
Laura Brown took meters from Hanna, gave them to Dr. Babcock, and observed the testing that he was doing. Oh, did somebody
Everybody's
say?
missing my point, right?
No, wait, I'm sorry, Your Honor.
I think you get it.
I get it, Your
Bless
Honor.
you.
Prior to,
Prior to.
I get it, Your Honor. Well, I'm there. It's a two-level issue. Your issue, I'm 100%, I understand. I think.
I mean, that's the issue in the case.
That is.
That is, Your Honor, and that's the problem with the discovery violation, is because they've repeatedly inferred and suggested 2 days is enough. We've done, Brian Moore did testing, he must have, because the tip card says 2 days. That's the prejudice from the discovery violation, because they never produced any Brian Moore testing, yet they're trying to act like it exists and it proves their point that 2 days is good, when there's questions about that. 4 to 5 days minimum, inconsistent, even in 4 to 5 days. So then withholding this testing, and then even doing testing after, that would apparently refute their position, otherwise why withhold it? And then continuing to present evidence and make arguments that 2 days is sufficient. That's the problem, because you correctly identify the issue, and now they're taking that issue and abusing their position on it by withholding all this testing.
And I'll ask the question in a very simplistic manner. Was there any testing produced in this case regarding the conditioning of the platinum tips with the voltmeter from the time the conditioning kits were discontinued up until this event occurred, unfortunate event?
No, there wasn't, Your Honor. There was no testing produced.
So as a result of that, there wouldn't be a basis.
Well, the real problem, I think, is we have a request for question for all the testing.
No, I understand that.
They don't produce it. Then they want to say all of a sudden that there's this secret testing that Moore Brown did. The connection with warranty work, maybe, but he specifically said Hanna and the Milwaukee meters. So there must be some testing out there. And then they were trying to get her on the witness stand this week. Undisclosed witness with secret testing. That is really troublesome.
Well, I've said it twice now. Testing was done by Dr. Babcock. Dr. Babcock needed meters in order to do that testing. Moore Brown was a part of making sure that he got those meters. Okay. Number two, Moore Babcock's testimony would have been, how do you do troubleshooting? What's the SOPs at Hanna in order to do that? That would have been her testimony. Number three, the board's already done it. They've got rid of the testing of Dr. Babcock in this case.
But what about the troubleshooting testing? Where's
So
that?
there's no troubleshooting. It's, in your experience, it's your job. What do you do for troubleshooting?
And she was going to come here and give her results without being produced?
We did produce her in
Okay.
16.1.
Hold on, we got one.
The judge ruled
Go to the second.
The judge ruled that identifying her in the Henry case was not good enough because I did put down Gallagher, even though at Hollow, or Hollow, whatever you want to say it, all the people that I have are under Murchison and Cumming, and it's all there and was done pursuant to 16.1, that Henry's a coordinated case.
And that there was discovery since
Hold on.
you specifically on point that Moore Brown wasn't.
Let me address that. Hold on, let me address that.
Okay.
Your Honor, can I put up 756 on the screen? This is Hannah's responses to plaintiff's first set of requests for production.
Yes.
Could you put that up for me, Shane? 13 says, please produce true and accurate and complete copies of any and all documents related to safety tests, including up limited to calibration tests for your MW series meters between the years of 2011 to the present date. Request includes but is not limited to any test results, data, notes, correspondence regarding the test, and meeting minutes regarding the test. So certainly Mr. Brown's testing should have been produced in accordance with this request. And to the extent it was done as a part of their experts' work, it should have been produced. It should have been produced pursuant to the
Let's see
expert.
the response. Let's see the response.
Go to the response. It's a long objection. Keep going. Very long objection. Here we go. Stop. Go up a little bit more. Hanna responds to request as follows. On information and belief, to the extent any responsive documents exist, they are not otherwise comprised of trade, secret, confidential, proprietary information, Said documents will be in the possession, custody, and control of Hanna Instruments SRL, a separate entity domiciled in Romania. As such, Hanna is not currently in possession of any documents responsive to this request. So, in addition to Rule 33, that would be Rule 34 violation, Your Honor. And to the extent,
I understand.
one other thing, and to the extent that Mr. Babcock or Dr. Babcock relied on any testing that involved Ms. Brown, it should have been part of his job file disclosure, Your Honor.
And he actually testified that he got the meters from Hanna.
Your Honor, utility for water, we see two issues here, and the first issue, of course, has been very helpful as to framing that issue. The second issue, though, is the one that I find more troubling. And the second issue is, at one point, and I don't know if they misspoke, but they said there was some type of testing that was not produced because it was not finalized. And there was not a report. That's what I am troubled by, and that's what I need additional information on, because if there was testing that was done that's not finalized, it's still subject to what we've just seen, and I'm sure the court is going to look at this, well, was it in your control? It doesn't matter if it's in the custody of Romania. Was it in the control of the defendants? In this case, it should be produced.
And actually, possession, custody, and or control.
Yeah, and so saying the documents are in Romania is not a defense to producing them, but what I'd like to know is, if there was this testing that was not finalized, what was that?
Hey, Judge, I think we ought to let Dr. Babcock go unless we're going to hearing, play a deposition so we can finish this today, and then we can discuss the remedy at the close of evidence.
Well,
I know we want to talk about the remedy now, but if we talk about the remedy now, we won't finish the case in chief.
Yep. Okay, well, my last question. So was he gonna offer opinions regarding this?
No,
That's out.
that's out, yes.
That's out. What else is he, for what other purpose would he be offering?
I did say this, Your Honor, but I will repeat, because there's been a lot that's gone on since the last time I spoke. ORP is a measure of the ability of a solution generator to accept electrons, like measuring temperature with a thermometer. An ORP measurement takes from the probe, does not alter the substance being tested, nor does it add or take away anything from the substance. Number two, real water uses ORP as a primary determining factor of whether the proper amount of mineral concentrate was added to their product. Number three, a lack of basic analytical knowledge was exemplified in testimony by real water employees Casey Aiken and Blaine Jones. Number five.
But why is that important? For what purpose would that come to? Are we trying to use that as a potential defense? Because there you're talking about, you're really focusing on the potential negligent conduct and or training of real water employees, right?
No, Your Honor, I don't think so, because it has to be taken in tandem with his rebuttal report having to do with Dr. Nazim, who has testified. Opinions expressed by plaintiff's expert Dr. Nazim regarding potential hydrazine formation pathways during water electrolysis are unfounded and contradictory to a publication authored by Dr. Nazim himself. Due to the solubility of nitrogen being well below the concentration of hydrazine measured in US EPA testing, formation of hydrazine during water electrolysis was highly unlikely. Now that's what Dr. Najim testified to in this court. Number two, the 67 causes of action for plaintiff's motion for leave to file amended complaint on order shortening time cited several statements in support of claims that the MW500 ORP meter was defective and unreasonably dangerous. Again, I think I said with regard to this, I think that particular part has been abandoned by the plaintiffs. They are not seeking in the verdict form anything with regard to the unreasonably dangerous part of the ORP meter. If I'm wrong on that, the plaintiffs can tell me.
Well, I think that's, you're not framing that correctly, because they still may have a products liability case.
Yes, they do.
And all products liability cases pursuant to the restatement of torch 402A focus on the product being in a defective condition and needs to be dangerous. The issue, and so they're saying that, but they're not saying it based upon manufacturing defect or design defect. They're saying it's dangerous because there was inadequate warnings given with the product. And just as important too, your client was well aware of the use of this product to give negative work readings, because 30% of the clients were using it for that purpose. That's the case.
Yes, Your Honor, and so as unreasonably dangerous as far as the instructions on the tip card is where we're at. He has one right here, condition of probative sold by vinegar instructed on the tip card. We would then give and that's part of section 7 of his report. I just read it.
But how can he opine on the conditioning time period? And then we're gonna bring the jury in. Because I have a question, how can he opine on whether or not?
Vinegar?
I mean, the vinegar or whatever, but he would, in order to make that determination as to the appropriate time period, he'd have to do testing.
There's nothing on the time. This is a statement of, does vinegar oxidize noble metals like platinum? Yes. Part of the questions that the jury can have is, well, is vinegar even appropriate to do oxidation? He's a chemist. He will say, yes, it is appropriate to use vinegar to oxidize noble metals.
I don't think they can test.
I don't know that they do or don't, Your Honor,
I don't
but
think they have.
But I think it's, the difference is the 4 to 5 days and 5 minutes.
Well, no, I understand that, I do. I mean, but I'm talking about using vinegar for the purposes of oxidation. I don't think anyone's contested.
Not a theory, Your Honor.
but this card is wrong on all levels. It's just wrong. But whether or not vinegar,
I'm not saying this wrong, and I don't disagree with, I'm gonna disagree with that because that's not my job,
I agree with you, Your Honor.
to say
The
that.
plaintiff's position has been that the tip card is wrong on many levels. And one of those levels could be, should vinegar even be able to be used? Okay? And
He never said that, Your Honor. There's no evidence of that. You say that the warnings with the meter are inadequate because they fail to warn of the hazards, they fail to properly instruct how to avoid the hazards, they're inconsistent with 48 hours, 4 to 5 days, 5 minutes, the people didn't know, they were relying on this, they were doing it wrong, and people got hurt. That's the theory. It has nothing to do with whether vinegar oxidizes metal or anything like that. It's just confusing and irrelevant.
But continue, anything else I need to know, because this is what we're gonna do. I can just tell you this right now. I'm not gonna strike him, but his testimony better be in accordance with this case. And I don't know all you plan on getting from him, but it appears to me that potentially some of it could be cumulative. If he crosses the line, there'll be a problem. That's all I can say.
thank you, Your Honor.
So I'm gonna let you put him on. You know what the case is, you know what it's about, and so on. We need to bring the jury in and get this case moving.
We do, Your Honor. I just want to make a quick point on the record. If Flora Brown mailed the meters, I don't really have an issue with that part of it. But if there was testing done by Laura Brown that we don't know about, and it sounds like there was something that was not finalized that we don't know about it, then we want to reserve our right to inquire into this after we're doing today. Because
I understand,
you
there's
did
no
shoot
waiver
first.
there.
And we want to talk to Mr. Babcock about it, either inside or outside the presence of the jury.
And, Your Honor,
Dr. Babcock.
I'm concerned a little bit about this because I think the court's gonna make sure, and hopefully Mr. Rasmussen will make sure that he stays within the confines of what the court has articulated to all of us. But if we were to do a proper voir dire on this issue, it can't be done in front of the jury. Because if we find that Mr. Rasmussen does not know everything that happened or has not produced everything that should have been produced, then that's gonna result in the jury actually witnessing a discord or a disconnect between the expert and the attorney. That's gonna be, I'm sure, Hanna would claim some form of prejudice. Additionally, given what we know and what we don't know, this may be the basis for stronger Rule 37 sanctions. And plaintiff is not waiving, we're not waiving our rights to avail ourselves of those remedies under Rule 37. But I think I want to voir dire this guy, Mr. Babcock, or Dr. Babcock, on these issues, but I see the potential dangers of doing the same. I just put that there, in front of the jury. Yes.
Sir, just want to make sure it's on the record that my client, Hanna Instruments, never received never asked for the real water product itself. Therefore, whatever testing was done was not of the real water product, which was the subject of this.
Well, I guess that makes it worse. We will have to talk about this issue when we have more time.
Yeah, Judge, getting back to my suggestion, maybe we should just play the videos and then ordeer Dr. Babcock. At least we're done with the evidence other than Babcock.
His flight is going to prevent that now.
The judge, he'll just have to take a red off like that to Chicago tonight. That's the issue.
Mr. Hoffman flies out every night, late.
No, he lives in Chicago.
He lives in Portland. He's
Oh, that's
from
all right,
Chicago,
still
but he, right?
You know, I appreciate everyone, and I understand what's going on, and I don't think he's going to be able to answer any questions for you with regard to Laura Brown, but it's also the centimeters.
Well, you said she observed. First you
Well,
said.
no, his results as they're being done, she observed that
There'll be no
with me.
results. There'll be no results.
Yeah, it's out. We can't do that.
Hey, Judge, I just wanted to close the argument this Monday.
I understand.
Yeah.
Gosh.
Like I already said, there's a red eye flag Chicago, if you wanted to be on the 445 or whatever.
Do you want me to get him on or not?
I think we should do the depositions and then we'll take a little more time with Dr. Babcock.
I'd rather not. I can certainly put on the Casey Aiken deposition, and we'll go with Dr. Babcock.
All right.
What we were going to do.
Yeah.
I appreciate you wanted to do my case in a certain way.
No, dude.
No, I'm just trying to get, well, I wanna actually, here's my concern. I mean, I wanna have you to put your case on, but I think there's some issues that have arisen regarding testing, what's gonna be the basis of this opinion, whether or not those test results were shared with the other parties to this litigation. And just as important too, here's the real issue is testing done by your client and or someone up the food chain from the time the tip cards were no longer, I'm sorry, by the time the conditioning kits were no longer sold in the United States due to the recall in the European Union because of the chemicals that I guess were utilized for the purposes of conditioning the platinum probe tips, right? I mean, that's really, and so what happened from the time of the recall up until this unfortunate event to measure or to determine what would be the appropriate conditioning time? Because for now, we have evidence all over the place on that specific issue. But, and Mr. Odou, I always like to hear from you.
No, I'm good, Your Honor. I was going to talk to plaintiff's counsel while we get ready for the next part of the jury convening.
So what do you want to, so you're concerned about your client? I'm just telling you, talk to him.
I'll do that.
Because I want to get this done. And if there's a problem, there'll be, you know.
Don't talk to him about the testing issue.
Oh, no,
Maybe you don't want to talk to him.
testing is not coming in.
I agree. You've already agreed on it.
It's not coming in.
But, Your Honor, just to be clear with this, it's testing and all the opinions and references and testimony that's based on the testing as well. He can't come in and just not talk about the testing and say, well, 48 hours is a perfectly fine amount of time to oxidize the probe. That's the key point that is out.
All right. Because if that was the case, there should have been testing that was done. Potentially, if it was done during the course of litigation, plaintiff's counsel and also Mr. Odou might have had a right to sit in and view the testing, right?
Videos of this testing was actually produced.
Mr. Babcock's testing has been excluded, that's not.
Yes, but you're asking me, what's this testing that's being done?
Okay.
That's the testing.
Mr. Odou, did you have another?
No, I'm ready to proceed.
Okay. Let's go. Let's bring the jury in, Mr. Marshall.
You got it, draw.
All right, to the jury. Please be seated. Thank you.
All right, to the board, Ladies and gentlemen, I apologize for the delay, but we had some issues we had to resolve. resolved outside of the presence. I think you understand that. But it's my understanding we're ready to continue with that defense case in chief. Is that correct, sir?
Yes, Your Honor. Oh, sorry. Go ahead. I misheard the court, I apologize.
No, you didn't, sir. You should have said, Mr. Rasmussen's ready to continue.
Your Honor, will call by video Casey Aikens, volume 2 of his deposition.
Right, at the time they hired you for that job, Mr. Aiken, and don't take this as a criticism of you, but you didn't have any food processing experience, did you?
No.
Or food safety training?
No.
No chemistry or metering experience?
No.
No background in sanitation?
No.
Was your construction work in plumbing?
No.
And you were maintaining the mixing tanks and pumps and plumbing lines and fill machines?
Yes.
And you were testing the product using the meters that you were given?
Yes.
All right. Mr. Aiken, were you given a checklist or a how to do your job list? A paper?
No.
An SOP?
No.
Were you given any manuals for the equipment?
No.
Not for the ozone machine?
No.
Not for the UV lamp?
No.
Not for the 5-gallon fill machine?
No.
And not for any of the meters?
No.
Were you given a maintenance schedule of any sort or a sanitation schedule?
No.
Were you given a spec sheet for the water product? A recipe, a formulation?
No, nothing on paper.
Were you given anything written at all?
No.
Tab number 2, Mr. Aiken, incoming water testing and treatment. Is this a document that you were given at all during your training before you were assigned to be the lead technician for the 5-gallon fill machine?
No.
And just down at the bottom it says each time the above is done, and it's talking about testing, take 2 sample bottles, open and test 1 bottle, write the manufacturer, date, code, shift, ORP, TDS, and pH value on the unopened bottle and keep that as a sample. Were you ever trained to keep retained samples?
No, not until after, after I started at Henderson location.
And when you say well after, is that well after the complaints came in about people getting sick from the 5-gallon product?
Yes.
But prior to that, you'd never been given this SOP or told to retain samples?
No.
And prior to that, Mr. Aiken, had you ever been given the product specifications in a document like this? That is the range for the ORP or the pH or the total dissolved solids?
No, I was never given it.
Never given that?
Not that I remember. No, I don't remember seeing any of this.
Your training at Henderson was all verbal, all oral, nothing written.
Right.
And Mr. Jones just explained what was to be done pretty quickly.
Yes, fairly quickly.
Give me an estimate on how long that took.
It seemed like a pretty simple process, so when he explained it, it was just basically step 1, 2, 3, went through it, and then I did it, and that was pretty much it.
And no documents he gave you to look at or refer to later?
Like I said, when the complaints started coming in, we went over some things like that, but I wasn't given any documents to take.
Okay, and then up at the top it says, for the large tank, above large tank, it says 2 concentrate, 1.5 scoops minerals?
Yes.
2 gallons of concentrate, is that what that means?
I believe, if I remember correctly, we had 5-gallon jugs of the concentrate, so I'm guessing if I did 2, it was two of those.
2 full jugs.
As far as I remember, that's what I believe. Like I said, it was so long ago that I don't even remember the actual mixing that we did. But I wrote down what I did just to make sure that I kept track of it for myself.
Yep, and let me put a finer point on it. You were never given any spec sheet or recipe or formulation better than that, were you?
No, just go by, what the test comes out in the ORP meter and go from there.
So that's another difference then. There was no taste testing before the complaints came in. Anthony brought the complaints to you, you started doing taste testing.
And that's when Blaine brought me those papers and we had that little training and we said, that's when he went over what he could. What I remember was going over everything for the meters to, basically what I'm supposed to be doing and changing the formula back to whatever he said. Because when I called on the phone that time, when the readings were off on the ORP meter, he verbally told me on the phone to change it to this, just add more. So I did, and it started coming out right. And then when the complaints came in, that's when he came in and trained me up on doing everything with this stuff here.
Complaints came in and then you really got trained up right.
Correct.
You started using the forms and you were given some of the documents and you cut the concentrate back by half.
Correct.
And started doing taste testing.
Yes.
And we're told really how to use the ORP meters.
Yes.
And did you have a higher degree of confidence in what you were doing after that training than you did before?
Oh yeah, I just didn't want people to get sick.
Sure.
Okay, in the middle there's a box, okay? It says Milwaukee at the bottom. Measurements made easy says underneath it. You see the word measurement?
Yeah.
The ORP, does it do measurements of ORP?
pH, ORP, EC, TS, LUX, temperature.
Right, so it does all those things in your mind?
Yeah.
Did you use it for all those other things like pH, ORP, EC, TDS, lux, and temp?
No.
Okay, what did you use the meter for?
The amount of concentrate, I think, is what it measured. If it was the right concentrate, like the ORP, that was the measurement we used.
Okay, so in here there's a display, correct?
Yes.
Okay, and that display gives you a number, correct?
Mm-hmm.
So there's also a black button on this. Do you see that black button?
Yeah.
So in order to operate this ORP meter, did you push the black button and it would turn on?
I'm sure I did.
Okay, and were you trained to just push the button and it would turn on? If you push the button, it would turn off. Do you remember doing that?
I believe so.
Okay, and then when it turned on, there would be a display that comes up on that LCD board. You see that?
Yes.
The kind of the gray area?
Yeah.
And there's a number that's there, and this one is a display, so it kind of gives you a number, I think it's 7.01. You see that?
Yeah.
Okay, and you don't know what it's doing there, what's being hooked up to it, but is that what you remember looking at when you did your ORP meter measurements?
Yes.
Okay, and when you took a measurement, whatever is in that display, is that always the number that you recorded on that log that we just looked at not too long ago? I think it's at exhibit 34?
Yes.
Okay, so whatever was in that display is what you wrote down?
Yes.
Okay, and do you remember, looking at all this, ever seeing any of the other documents that are up here on the top?
No.
Okay, do you ever remember seeing the box?
No.
So, while you were there, the only thing you were given was the meter itself, correct?
Yes.
And Blaine explained to you how to use it, correct?
Yes.
And his explanation was, you turn it on by pushing the black button, and you turn it, and then you hit it again and it turns off, correct?
As far as I remember.
All right,
Yeah.
that's the meter part, right? And then if the display is what's in that gray area, correct?
Yes.
Have a Dixie cup
Okay.
right before you get an ORP meter reading, correct?
Yes.
Okay, and you would take the Dixie cup over to the valve on the hose or the PVC lines that come out of the mixing tanks, correct?
Yes.
And it would come down to a spigot, correct?
Yes.
And you would put the Dixie cup underneath the spigot, correct?
Yes.
And you would turn the spigot on and water would flow out into the Dixie cup.
Yes.
And then you would turn off the spigot so the water would stop, correct?
Yep.
Then you would take it where? That sample of water. Where
To the sink.
to the sink. And then you would take the ORP meter probe and put that into the sample cup of water. ORP meter reading was done after a 5-gallon jug came all the way through the bottle machine. All of the washing was done to it, and then it would come out of that the machine where it was now filled, and before it was capped, you would put the probe in the water?
Yes,
Okay, and then you would get a reading,
yes,
and on your handwritten notes, you would write that down.
yes,
Okay, and then you would cap it, that one, and that could be sent out.
no.
Okay, well,
That one I would dump out.
so any water that was bottled and sent out to the public for consumption never came in contact with the ORP probe. Is that correct, sir?
I don't understand.
Okay, so I have an ORP probe,
Okay, yes,
and it
you're right.
never touched water that actually went out to the public.
Correct. Well, the main mixing tank
Yeah.
is what was filling the bottle,
Right.
and then all of the bottles. So the first bottle that came out, as long as it read right, the rest of them should follow suit.
So in fact, the ORP probe never touched the water that would actually reach a customer.
I guess technically no.
Do you see that, sir? In the middle there, I've got something called a Milwaukee MA 9025 ORP Probe Conditioning Kit. You see that?
Yes,
Do you remember ever using that particular kit for the probe that was attached to the Milwaukee ORP meter?
no,
Okay. Do you remember seeing that kit?
no,
Okay, this was at the Henderson plant. Did you see anyone else that had this kit?
no,
Have you ever seen that kit before I showed you in this picture today?
no,
Okay. Do you know if anyone was doing conditioning of the ORP meters at any time there?
no, not that I know of.
Do you remember any discussions with anyone with regard to the ORP meter conditioning?
No,
Okay. Do you remember any condition of the ORP probe?
no,
Do you know what a millivolt is?
no,
Do you know what electricity is, right?
I do.
Like all of us do. And do you know what a measurement in millivolts does with anything?
No,
Okay. So if it says that the ORP meter does a range of plus or minus 99 millivolts, voltage of something, that's what this Milwaukee machine or ORP meter does. Did anyone ever tell you that it was just measuring voltage?
no.
Did you think it was doing something else?
Well, yeah, I thought it was measuring the, whatever we were putting in the water to make sure that it was safe.
Okay, so if it's only measuring voltage, that's new to you, right?
Yeah, absolutely.
Okay, now, what does electrical current have to do with what you thought you were doing?
I wouldn't think anything.
So there wasn't anything like reading for contaminants or reading for other kinds of chemicals, nothing like that, correct?
No, just the negative number that I was supposed to put. Yeah.
That's all it ever did, right?
Yeah,
Do you know what currents of electricity have to do with what you were doing at all?
no,
Do you remember ever seeing this particular document or tip card, anything like this?
no,
Did Blaine ever show it to you?
no,
Now, that probe at the very end had a little tip that was made out of metal. Remember that?
yeah,
Okay. And that's what would go into the 5 gallons that you would discard later. And that was made out of platinum. Did you know that?
no,
Did anyone ever tell you that?
no,
Did you know what it was doing when it went into the water?
no,
Okay. Did you, other than reading the number that came off it, did you have any other information about what was going on with that ORP meter?
no,
Okay. And in your background, do you remember having any, for lack of a better word, training or education in science or laboratories or chemistry?
no,
And then on the other side of the box, there's this right here. It says ORP meter model MW500. Okay? And you recall that was the kind of ORP meter that you were using?
I would assume so.
Okay. Last one is this side. I'm going to show you this here. It has a warning. It says, we'll read that. The enclosed product is intended for use by persons knowledgeable in safe laboratory practice. You see that?
Yes.
Sir, do you consider yourself someone that is knowledgeable in safe laboratory practice?
No.
Do you think that the conditions in which you were using the Milwaukee meter was a safe laboratory practice area?
No.
Was there anything in where you were using this that looked like a laboratory?
No.
Okay. And you know what a laboratory is because you've seen them on television or at high school when you went to the, when they teach us science and stuff like that. None of those in where you were doing this was this a safe laboratory practice, correct?
No.
Okay. All right, then it says information concerning limitations of Milwaukee products can be obtained from Milwaukee Electronics Kit. Do you remember getting information from Milwaukee on the use of its?
No.
Or do you ever got any information about how to use this, or is this the first time today that you're seeing these particular warnings, correct?
Yes.
All right, let's go to the next one, which is 3889. ORP New Probe Conditioning Instructions. Do you see that?
Yes.
Okay, and this is what we have here. Oh, and then it talks about the ORP probe should be conditioned before being put into use, and this should be done about every 30 days to ensure accuracy of your unit. Do you remember if you conditioned these probes?
No, I don't remember doing that.
Should have been something that should have been explained to you by Blaine?
I would think so.
Is there anyone else like Anthony that would have told you how to do this?
No, you should have.
Okay, nobody ever did?
No.
Do you remember seeing any of these bottles down here below, the reducing solution, oxygenation solution? Remember seeing either of those?
No.
Do you remember if either of them were used by you?
No.
Okay, but they were at the facility. This is where this picture comes from. But no one ever gave these to you, correct?
No.
Okay, and so you never used these with these instructions on how to condition, correct?
No.
Okay. Do you know why someone wouldn't give this to you? Is there a reason? Was there someone else? So do you know if using this was the correct way to condition the probe?
It should have been conditioned, as like the directions say, every 30 days.
Okay, and you never did that?
I never did that.
Okay. When you finished using the probe, let's say you did a reading with one of the 5-gallon jugs, and then the water would be discarded. You took the probe out. What was the next thing you did with it? Did you clean the probe? Did you shake off the water? What did you do?
Just put it in the
case.
case.
Okay. And that case was filled with with something. Do you remember what it was?
No, I don't know.
Did you ever feel well when you used an ORP meter?
No.
Do you believe that you were sufficiently trained on how to use an ORP meter at any time while you were working for Real Water?
No manuals or anything like that, but as far as Blaine showing me how to use it after the complaints started coming in, yes. Anthony showed me how to use it.
Okay.
By, this is what you do, you put it in here, you look at the number says what you want it to say, and then you move on.
Did you ever see something called a Pro ORP meter manual?
No.
Yeah, okay. Did you ever, you can take that one off, we can just go back to that regular screen now. So if I showed you the user manual for that, this would be the first time you would ever have seen this as at this deposition.
Yeah, I never saw any kind of manual or anything.
Do you know what an ORP meter does? Now you do.
Now I do, but yeah, never before. I just was measuring something in the water that needed to be between this and that.
Sometime prior to September 30th, they would have explained to you in general how the ORP meter worked, right?
Yes, in general.
Okay, and I think you've already said that you have had some kind of general training at Desert Inn with regards to the ORP meter, right?
They showed me how to put it in the water and read the number. If that's general training, then yes. But other than that, I mean.
Do you recall ever being told how long you should submerge that meter in the either water or vinegar or whatever substance or fluid you use?
No, I've never been told how long to do it for.
Do you recall ever using vinegar to be put into the cap that the probe from the ORP meter was placed into during the time you worked at the Henderson facility?
I believe that is what we put in there, yes.
Okay. And do you know if, when the day ended, that it was just stored in vinegar overnight?
Yes,
Okay, and so it would stay there for hours in vinegar if it wasn't in use? would it?
yes.
You told me you didn't remember one or the other, whether it was water, vinegar, and now you just said vinegar. Is it true you don't remember specifically one or the other?
Just like I said before, there's only one reason that we had that vinegar in the bay was to put it in that ORP meter. I don't remember, because my brain doesn't compute 2 years ago and what exactly I did here and there, but yes, I remember there was distinctly a different solution other than water going into that container that you put that prong in. So I do remember it was something other than water, and there's only one other thing that could have gone in there, which would have been vinegar.
But you don't remember one or the other, but you're deducing that it was vinegar, correct?
Yes.